Good afternoon. It's so good to be back. We're happy to be here today and to talk to you. I guess the question was Equal Access to Justice Act, and I'm sure everyone's thinking, what in the world? What does this have to do with us? How does this affect us? Isn't this just about, aren't the courtroom's doors open for everyone? Why do we need to learn about this? So we're going to talk to you about this and why you should care about what's going on with this act. So let's start off with Heath. Can you maybe tell us a little bit about where this act came from and what it requires and what it does?
Yeah, so Equal Access to Justice Act, commonly referred to as EJA. Essentially what it is, it's a law that allows businesses and individuals to recoup attorney's fees and other legal costs if and when they are the victim of an adverse action by the federal government, they sue, and the action is overturned. They can recoup their costs from the federal government. The idea behind EJA was really born in the 50s, 60s, and 70s when the federal government started passing a lot of our bedrock environmental laws that we have today, like the Clean Water Act, Clean Air Act, NEPA, Endangered Species Act, including a whole host of other laws and regulations that came into effect. And suddenly, businesses and individuals found themselves kind of under siege by this heavy burden of federal laws and regulations. And there was a concern that some of these laws and regulations, there was some overreach amongst federal agencies, and people were being harmed by some of these new laws and regulations. And if at the time, if you were a big business or a wealthy individual, you could take the federal government to court and sue, and you could win and get the action overturned, and you could afford the legal fees to do so. But if you were a small business or you were an individual without the means to hire a team of attorneys to litigate, you didn't really have a choice. You just kind of had to live with the action, because even if you did take the federal government to court and you won, you still had to pay the exorbitant legal fees, and sometimes it just didn't make sense. So EJA was passed in 1980 with the intent of making sure that everyone had access to the justice system when it came to adverse actions that they had suffered at the hands of the federal agencies. So that's really what the law is and where it came from.
Can I just add something to that real quick? You know, EJA was a great idea. That it's one of those things in Washington, D.C. that just turned into a weapon instead of the idea that it was intended for. We all agree that mom and pop shops and grandma and grandpa, if they have an issue with the federal government, they should be able to sue and recoup their costs. Unfortunately, this, like I said, has been weaponized by special interest groups. And I kind of akin it to a bully that hits you in the face and then you pay him $100 for him to hit you again, because that's what we're doing. We're paying these special interest groups money so that they can turn around and use that money to sue the federal government again and litigate on anything that they don't like, and we're footing the bill for that.
Well, and in response to that, there were some reforms just recently, just a few years ago. I mean, maybe, Pete, you could just explain what those entail?
Sure. Good afternoon, everyone. Melissa, thanks so much. And before I get started, just thank you for inviting me, and thank you to my friend Cody Stewart for connecting me with this event. It's amazing to look out and see all these friendly faces. One I need to just give a shout out to. I'm the president of the Petroleum Association of Wyoming, so I represent the oil and gas industry in your neighboring state. And it's unusual for us to encroach upon the territory of our sister association. So I don't know if Ricky Rinko Browning is in the room. Oh, she's in the back. She's waving. If you don't know Ricky, she's my counterpart at the Utah Petroleum Association. UPA is doing amazing work these days. Innovative, active, energetic. They're just doing an excellent job. If you've not connected with UPA, please do so. And Ricky, thanks for letting me be here today. So real quickly, Melissa, you asked about how it's changed. So prior to taking this job here, I spent about a decade on Capitol Hill for then Representative Cynthia Lummis. She's now the U.S. Senator from Wyoming, works with Senator Lee pretty closely on a lot of things. And we, Senator Representative at the time, Lummis, and I spent about a decade trying to deal with the Equal Access to Justice Act because of the way that litigious environmental groups were able to, seemingly without any sort of resistance or any sort of knowledge, access an enormous amount of taxpayer money to fund their repeated litigation. And when I say repeated, for example, the Center for Biological Diversity at the time, I haven't done a recent check on it, was filing on average two complaints against the federal government per week. And they were accessing EJA funds to the tune of millions of dollars. I think just recently, I was just looking the other day, just in FY 2021, Center for Biological Diversity has accessed about $686,000 from EJA in FY 21 alone. So, I'm trying not to monopolize this here, but essentially what Representative Lummis and I were facing at the time was we knew that there was a problem, but there was no access to any information about the problem. And so when we would say, how is it that CBD is getting all this money and Wildwood County is getting all this money, like we've got to fix this thing, we've got to fix it. They would turn around and say, what's the problem? There's no problem. You don't have any evidence of any problem. Part of that was because, as part of, you all know, the unintended consequences. You might remember back the contract with America back in 1994. Heath mentioned that EJA passed in 1980. It sort of chugged along, funding the people it was intended to fund, small businesses, individuals, people threatened by the federal government in undue ways. In 1994, contract with America, part of it was reducing paperwork, reducing government reporting, unnecessary government reporting. So they passed a bill to reduce what they thought was unnecessary reporting, and EJA was swept up with that, in that. So 1994, reporting on how much money and to who these dollars went away. So from 94 until we were able to finally pass the amendment, was called the Open Book and Equal Access to Justice Act, there was just simply no reporting on it. You had to comb through individual litigation, you had to comb through 990 tax forms, all that kind of stuff in order to find out who was getting the money, how they were getting the money, and what and where it was going. So we had a lot of reforms in mind, which I imagine we'll come on to, that we would have loved to have passed. It was a very difficult 10-year effort, essentially, to get the open book to equal access to justice in place. But now, as a result, you can, in fact, right today, you can go look at reports of how much money is coming out from this and to who it's going to and how it is that they achieved the money. We would often say, look, you can get equal access to justice in the case of environmentalists, you can get money from EJA, win, lose, or draw. And that's still true today. That's not true for the people it was intended for, small businesses. You have to win. You have to prevail on the merits in those cases. You do not have to prevail on the merits in environmental cases to get money from EJA. And that's a very important point, which we can talk about later, and I'm not going to monopolize. Thanks, Melissa.
No, that's great. And I think some of the numbers, to put this in perspective, when they were trying to figure that out to make those recent amendments, the Department of Interior alone, in just 5 years, from 2012 to 2017, paid out $4.4 billion, yes, with the B, dollars, in over 450 settlements.
Can I add to that as well? That's settlement money that went out directly. What that doesn't include is all the costs to your businesses, agriculture, other entities in costs, in delays, projects that will never happen because there was the sue and settle aspect of it, that the agency just gives up on an action because they settled and then paid out on these lawsuits. So it's billions of dollars more in lost revenue to states, industries, everybody else.
And the Department of Interior, they wanted to increase transparency similar to those changes. And maybe, Redge, you could just talk a little bit about what they did in response to that.
Sure. So under the last administration, there was an effort to really address EJA. So we had the Dingell Act, which put some congressional sideboards on it for reporting, which those are still in place. But both the Forest Service and the Department of Interior, two agencies that I deal with a lot, both the secretary the secretary of both of them put secretarial orders in place where Forest Service and Department of Interior had to report within those agencies, and they had it on their website, and it was very transparent about everything that was being paid out. And interestingly enough, some of those payments decreased a little bit over that year and a half that they were in place. Unfortunately, the current administration, the Biden administration, he's allowed those agencies to remove those reporting. So they're no longer reporting at the agency level. The Congressional Act is still intact, and they have to respond, or they have to report to a congressional office, which was, Heath, what was that again?
Jeez, I can't even remember what it's called. It's some
So-
agency I'd never heard of before.
Some nondescript federal agency.
The Administrative Conference of the United States.
That's it.
Say again.
The Administrative Conference of the United States.
How many have heard of that agency? Yeah, so it's kind of hidden, and which is why we're trying to put a spotlight on this issue. It needs to be brought to the forefront, and we need everybody's help in the room to bring this to the forefront because we need some significant changes here. Litigation, as most of you know, is the main cause of delay in NEPA. Agencies spend so much time trying to litigate proof NEPA that it takes years where it should take months.
And it's really problematic because what happens is they will agree to changes that completely circumvent the normal notice and comment rulemaking process. So I guess the question is, how is this really affecting all of you in industry? What are we seeing this? And maybe Pete, you can talk about some of that. Are you seeing the impact?
Yeah, and thanks, Melissa. And I would, so I want to be clear on this part because it's weird. I think if there's somebody who's watching this who might want to try to poke holes, would say, what's the oil and gas guy doing talking about money going to help 501c3s sue the federal government? You know, gas is whatever it is right now, not as high as it was, and so you guys have all the money in the world, is the general attitude. So what are you talking about? So let me just be clear. When I was working for Representative Lummis, and still today, the issue for us was never about shutting off access to the federal courts. Heath mentioned it. The federal government can and does get it wrong, and they get it wrong in some pretty dramatic ways. They have enormous resources and lots of manpower to go after citizens and businesses of the United States, and having the ability to defend against that with a program like EJA is unbelievably important. We want the ability to sue the federal government just like we did when President Biden issued the moratorium. We have filed litigation to try to overturn that, as was mentioned. We're defendant interveners in another lawsuit, which I can get to in a minute. We want that access. We're ineligible for EJA because my businesses, my member companies exceed the income cap, so we're ineligible. But our issue is getting the incentives right about when to sue. Where should policy be derived? Should it be derived behind closed doors and settlement agreements with courts? Should it be derived by the people that we elect as citizens of the United States in the Article I branch of the federal government, where they can decide, Senator Lee and Senator Lummis and others can decide what our energy policy is. So if you look at any of the litigation that's filed right now by CBD, Western Watersheds Project, Wild Earth Guardians, any of these organizations, and you just flip to the very end of it. You don't have to read through the whole thing, just flip to the very end and you'll find basically boilerplate language in there that says that they're going to just seek attorney's fees, and other costs, et cetera, et cetera. And so in our case, I mentioned to Heath earlier, we just filed as a defendant intervener in a lawsuit brought by CBD and Wild Earth Guardians that seeks to invalidate every single oil and gas permit issued in Wyoming and New Mexico since President Biden was elected, trying to overturn all the permits the minimal permits that President Biden's administration has issued. That's obviously an existential threat to us. So PAW has filed to intervene, the state of Wyoming has filed to intervene, API, the American Petroleum Institute, the New Mexico Oil and Gas Association, 4 of my individual members, Chevron, all of us.
And the state of Utah,
And
just on
thank
Friday.
you. Yeah, thank you for doing that, by the way.
You're welcome.
All of us have to do that, spending tens of thousands of dollars of money that could be into actually, economy driving decisions. And for them, there's no downside. Maybe it gets dismissed as frivolous. Doesn't matter. They can still recover their attorney's fees. And they've still made us spend all this money on it. Maybe they go to settlement and they get a policy objective they want behind closed courtroom doors. And the settlement stipulates that they prevailed. Again, they get their fees. Maybe they win outright. Of course, that would be dramatic for us, and I don't think is likely, but they win in that case as well. They win on these things, win, lose, or draw, so the incentive is wrong. We have to get those incentives right so that we have an even playing field.
I'll just jump in. So Pete mentioned that his company isn't eligible to recoup their legal fees from the federal government. That's because within EJA, there are caps. I think it's for a business, it's $7 million, and for an individual, it's $2 million. So if you exceed those caps, you're not eligible. And so you may be thinking, well, some of these environmental groups clearly exceed the $7 million cap. With EJA, 501c3 organizations were exempted from the caps. So all of these environmental groups, no matter how much money they bring in every year, they are still eligible to receive compensation for their legal fees. Another interesting aspect of EJA, within the law, it caps legal fees at $125 an hour. And that there is an adjustment for inflation in there, but for the most part, if you're going to seek EJA fees, $125 an hour is about the cap you can expect to receive. However, there has been some court decisions that have recognized specifically environmental litigants as having a specialized knowledge base or specialized skill level, and they consider that an exception to the statutory cap of $125 an hour. And so environmental groups, not only are they not subject to the income caps, they also aren't subject to the statutory caps on hourly rates like everybody else is. And in some instances, courts have awarded environmental groups up to $650 per hour in fees, which can far exceed market rates in some instances. So the environmental groups have really learned how to game the system and abuse EJA and take it beyond what it was ever intended for.
Now they're all going to want to become environmental lawyers, $650 an hour. Don't do it. No, but, and I think the importance of what some of these lawsuits are on a precedential basis, too, cannot be overstated. So, for example, in this case, or just a few weeks ago, we won a summary judgment motion in our challenge of Biden's moratorium on the oil and gas leasing. And that was a huge win. We had won initially in the courts to stop that moratorium, and that was a preliminary injunction, and now we just won summary judgment. But then just a couple weeks later, then we have another lawsuit where it's being challenged by an environmental group. And it's just one lease, and so it's easy to say, well, it's just one lease, why should Utah get involved? Of course we should get involved. One of the arguments they're making is that the BLM failed to consider the social cost of carbon in approving the NEPA and other analyses. And that can be huge in other cases. And not to mention, these environmental groups, as Pete was explaining, their motivation, they have every motivation in the world to draw this out as long as they can, because they're getting paid by the hour, $650 per hour. So those are the things that we're facing right now. Any other impacts that you're seeing, Reg, Sue and Settle?
So I think the biggest thing for us is on the settlements, that they basically get what they want behind closed doors. And I know it's been discussed already, but Governor Cox has asked our office to try and remove roadblocks for industry at the federal level, at state level, anywhere we can. But when you're dealing with nebulous roadblocks that just come out of the middle of nowhere from a settlement, that's problematic. We ran into one just about a month and a half ago on some roads down in Emery County where we went through the whole planning process with BLM. Everything was good. did the right process, then at the end came out, SUA litigated, and they got 184 road sections back, possibly closed off, just under a settlement, just under the EJA rules. So that's really problematic for us. So now we're spending a whole lot more time and effort trying to analyze those 184 road segments again. And they weren't good part, they didn't come to the table, so it didn't come to the table during the planning process with the roads, et cetera. They just know that they have this tool that they can use whenever they want to bring it out, and it creates a lot of conflict for not just oil and gas, but we see it with solar, we see it with grazing, with timber. I mean, a lot of our most catastrophic wildfires, there was NEPA to do a forest project there, guaranteed, but it got litigated. Then you end up with catastrophic wildfire and all the impacts that come from that. So it's more than just energy, it's across the board.
Well, we don't want to be the Debbie Downer panel for the day. All hope is not lost. So let's talk about some solutions that we think about these problems. Heath, why don't you talk about what Senator Lee is doing?
Yeah, so Senator Lee in his video mentioned that he's been focused on updating and reforming the NEPA process. He has a bill called the Unshackle Act that really takes a comprehensive approach to reforming all aspects of NEPA, such as imposing shot clocks to make sure that we don't have NEPA projects that drag on for 15 or 20 years, making sure that there's adequate reporting so that we understand how long NEPA is taking, how much it's costing, things like that. And he mentioned that he was even able to get some of those provisions into the recent infrastructure bill that passed. Even though he voted against that bill, we took it as a sign of encouragement that with a democratically controlled Senate and House and a Democratic president, we were still able to get some NEPA reforms into the infrastructure bill, which we took that as a sign that there is starting to be some cracks. Even some Democrats are starting to realize that the current NEPA process as it's operated now just isn't working. So we're hoping that that will naturally lead to the realization that there needs to be some reforms to EJA and to the legal process associated with NEPA. So as part of Senator Lee's Unshackle Act, a section in that deals with some of the legal aspects of NEPA and with EJA. So I mentioned earlier that the environmental groups can sometimes be accepted from the statutory cap on fee rates. So one of Senator Lee's proposals is to get rid of that exception for the environmental groups, make sure that everyone is subject to the same statutory caps. Because as Pete mentioned, it's really all about getting the incentives right. We don't want to completely scrap EJA. The original intent of EJA is good. Everyone needs to have an equal shot at challenging the federal government if the federal government is not acting appropriately or they're stepping out of their bounds. So we don't want to completely get rid of the entire law. It's really just readjusting the incentives. And right now the environmental groups have every incentive to enter into litigation because not only are they not subject to the statutory caps on fees, normally in the process of litigation, if you're going to sue the federal government to hold up a project, normally you have to put down a security or a bond. Basically the judge will say, okay, if you are wrong, if you lose this legal case and yet you've held up this project, you're going to cause some damage to the project sponsor, so you have to post a bond to make sure that you have enough to cover those damages. Well, judges have also been known to waive those bonds, those securities for environmental groups. So the incentives for the environmental groups, they have no caps on their attorney's fees. They also don't have to put any skin in the game by posting a bond, so they have every incentive to sue at every possibility and to try to slow down energy projects or infrastructure projects, whatever the case may be. So those are two of the things that Senator Lee has targeted, just to try to reorient the incentives to really bring EJA back to its original intent and to stop incentivizing so much litigation.
So if I can just add to that, hopefully give you some hope out there. My team, I've got about a team of about 20 attorneys, and we partner with the Solicitor General a lot on different efforts. So we have your back, and we're fighting like hell to protect what you guys do and to fight back against these litigious environmental groups and try to work with our congressional delegation on changes that need to be made. Kudos to the delegation for the changes they got in the Dingle Act that requires the reporting so that at least we know what the settlements are. We're also working to get not only what the settlements are, but what the settlement agreement was, because a lot of times that's more important than the settlement dollars, is what they agreed to. What did that agency agree to in that sue and settle? During the Trump administration, we saw very little sue and settle. Now we're seeing a real uptick again in the sue and settle. So we want to know what the hell they're doing behind closed doors, and so we're working on some of that. So we got your back. It's just going to take a lot of work.
Yeah. Pete, any thoughts on how to address this?
Oh, I have thoughts. Yeah. I always have
We want to
thoughts.
hear them.
So I think one of the most important things I learned about in this process was just understanding the intent, sort of Chesterton's fence sort of thing. And it's really interesting. Cody, you'll appreciate how odd this is. So the original EJA that passed in 1980 underwent 23 hearings in front of 12 committees in Congress before it was passed. So it's not like they didn't think about it. They tried to make this work, and they put in place basically. They tried to put in place these guardrails to protect taxpayers from paying too much. One of them was the income cap. And they, as a compromise, removed 501c3s. So that one for environmental groups is gone. The other one was you had to be a prevailing party. You had to win in order to receive the money. Well, that still happens for does anybody know the top user of EJA? Social Security disability claimants. They get denied disability and by the federal government, and they use EJA to sue the federal government to get their Social Security benefits. They have to prevail to get that. They can't lose. Well, in the case of the sue and settle that Redge was talking about, the federal government will stipulate, even if they won nothing on the merits, they will stipulate that the plaintiff prevailed. And that's the trigger to clear that hurdle for EJA. And then the third barrier they put in is that you're not entitled to an award from EJA if the federal government's position was substantially justified. So even if you win, but they were reasonable in their argument, you still don't get an award. Well, EJA is triggered generally on procedural grounds. So if you miss a deadline, if the federal government misses a deadline for whatever reason, there's no substantial justifiable reason for missing a deadline. Cleared that hurdle. And then the attorney fee cap that Heath talked about. All of those things can be fixed. And they can be fixed by keeping in mind the people that are important here. Social Security beneficiaries, veterans, that's the second highest group that uses this. Veterans who are seeking veteran affairs care and get turned down for whatever reason, they need this. We have to keep them in mind. And we can do that in a number of ways by making sure there was an amendment offered in 1980 that ended up being scrapped that said you had to have a direct and personal impact in the case to earn an EJA award. All of these environmental ones would be gone if you had to have a direct and personal impact in the action of the federal government. I think that's in your boss's bill, is that correct? Yep. And then the prevailing party side, we can ensure that you just can't, you have to win at least on some part of the merits before you can earn an award. You can't just be declared the winner even though you got nothing out of the case, which is what happens in these settlement agreements quite a lot. So there are ways to do it, but you can't even get off of home plate if you don't keep in mind the Social Security beneficiaries and the veterans who really need it and need it to work. Otherwise, it's untouchable.
Absolutely. I mean, I like suing the federal government. Redge and I just sued last week on monuments, so we like it. No, but I think those are all great points and the changes that can be made. Oh, thank you. Any last thoughts or any questions?
So, the abuse of this act, is it substantial enough to allow these people to have a career doing this? I mean, can they make a living off of this? And is this what they do day in and day out?
Yeah, there is a whole industry around this, billions of dollars over the years that have been paid in this, and that's just from Department of Interior and Department of Agriculture. So that's not the beneficiaries, the veterans, welfare recipients, those folks that have been denied there. We totally support that part of it, right? But when you see that much money being paid out from Department of Interior, that's an industry in and of itself. Yeah.
I was wondering where they got their money and how they, somebody can only give so many free hours, right? An attorney. And how they get these filed and continue. I'm going like, they gotta run out of money, but this is where they're going to make it happen.
Yeah, I mean, I encourage you, so that it's an odd federal agency, but it was the original agency designed to monitor this, is the Administrative Conference of the United States. They were under the bill that we passed that was included in the Jingle Act. They're now, agencies are required to give them the data, and they're required to post it. They're not the ones monitoring. Agencies have to give them the data. But you can go to it now, and I imagine we can find a way to get the website out to everybody. And I just encourage you to just search Western Watersheds Project. They were awarded an EJA award of over almost $550,000 in one award just this past 6 months or something like that. It's not that I'm hesitant to say that they're making money on it. They're probably not getting rich off of it. What it does allow them to do is to file 2 lawsuits a week that, for those of us who are trying to drive our economy forward, bottle that up. And as the taxpayers, we're paying for that to happen. So we just have to get those incentives right. Sue if the federal government is wrong. But don't expect taxpayers to pay for it if it's just part of this ongoing churn.
Thank you.
Jeff?
So we in industry appreciate the efforts you all are making to keep the federal bureaucrats honest and to push back on various activities by environmental activists. Maybe differentiate the way the state of Utah looks at the industry more as a partner or an ally on some of these issues, and maybe steps the state takes to work with industry to find legal solutions and give them a path forward.
Absolutely.
I'll take that first.
Oh, sure. And coming forward, if you see these types of lawsuits, contact us. We'd like to know. It's not always immediate that we're going to get notification of these issues, and we want to be involved. But we do see industry as partners. So, for example, Senator Lee talked about the Uintah Basin rail project and how that's being challenged. The state of Utah is coming in. We'll be writing an amicus brief in support of that, or in support of the 7-county coalition in that case.
So yeah, Governor Cox has been very specific to our office about anytime you see something like this, intervene. We have some limited bandwidth. We can't do every single case, but I think right now we're in around 70 active lawsuits. Almost every one of them has one of these groups that either is using or has used EJA as one of their funding mechanisms. So State of Utah has your back, and we do as much of this as we can, and we do, just as Melissa said, we need to hear if you're having some issues out there, there's litigation that we're not aware of, let us know, we can review it. I will say the state of Utah cannot represent individuals, right? So we can represent when the state's interests are hurt or county's interests are hurt, which generally, if your industry is hurt, our state interests are hurt as well, one way or another. So it's just a technicality, but just so you're aware, we can't represent individuals like veterans or things like that. So.